Hello, I'm Jeanette Miller, the Managing Director of Jeffrey and J.S. Miller Solicitors, and today I'm going to be speaking with one of my colleagues, Daniel Parisi. Daniel is the founder of DJP Immigration with offices in London, Brussels, and New York. And he is our go-to person when it comes to US immigration law inquiries. So before I introduce you to Daniel, I'll just tell you a little bit more about him. He's practiced immigration law since 2003 and has extensive experience with a wide range of business and employment-related immigration issues, with a particular focus on ineligibility for people seeking to enter the US who are inadmissible for criminal or personal reasons. Daniel regularly speaks on the issue of inadmissibility at several national and international conferences of the American Immigration Lawyers Association, amongst a number of other prestigious organizations. He's authored numerous publications on this topic for the association and has had his work featured in various legal publications. Daniel is currently the chair of the association's Europe, Middle East and Africa chapter, and he was formerly the chair of the Department of State Liaison Committee for the association. He's included as a thought leader in the publication Who's Who Legal Corporate Immigration. He's a graduate of West Virginia University from 1998 with a BA in International Relations and Foreign Languages, and he spent the majority of his undergraduate years in Europe, where he became fluent in both Spanish and French. In 2016, he was named Outstanding Alumni in World Languages by West Virginia University, and he received his Juris Doctor from New York Law in 2003, and then upon graduation was inducted into the Order of the Barrister, US, for excellence in oral and written advocacy. He is admitted to practice also in New York. Hopefully that bio explains why Daniel is our go-to person for any issues relating to US immigration law. I'm now going to switch over to the interview I had with Daniel, which personally I found incredibly informative. Hopefully it addresses all of your US immigration law questions. Okay, so we have Daniel Parisi with me, and today I'm going to be asking you to explain some of the most common questions that clients that I help tend to want to know the answers to. I'm sure that you are probably one of the most authoritative minds on this issue, so I'm very interested to hear from the horse's mouth, so to speak, what your take is on some of these points. So jumping right in, what I'd like to know, something very basic for you, I'm sure, is what is an offence of moral turpitude?
It might be basic, but I think the answer is no one actually knows. It's not defined anywhere. It comes out of old case law, and the historical definition is anything that shocks the conscience. It's certainly not a definition that we use anymore. When we look at moral turpitude, some offenses are strictly defined as moral turpitude by the State Department, by the US government, but most of them are not. And when we look to see whether or not a crime is going to involve moral turpitude, we look to see if there's intent to cause some sort of harm or to perpetrate some sort of evil activity. So the common offenses that we see that do contain moral turpitude are things you may be not thinking about. They're not all murder and rape, which clearly do involve moral turpitude, but they're anything with an indicia of fraud or theft or dishonesty, deceit. So even something as small as shoplifting something worth £5, because it's a theft offense and it's one of those things that is not a regulatory offense. It's illegal because it's wrong to do, not just because the law says it's wrong. That's going to be a moral turpitude offense. So anything with theft, fraud, arson, forgery, assault if you intend to cause harm to the person, destruction of property if you intend to destroy the property, possessing indecent images, those are all going to be moral turpitude. The list of non-moral turpitude offenses are things that we've made illegal because they disrupt the public order or there's some element of regulation to people's behavior, but not because they are inherently bad things to do. So things like drunk in public, public order offenses, traffic offenses, and even driving under the influence of alcohol are not moral turpitude offenses.
Okay, because I was going to say most traffic offences, intention's irrelevant. It's whether the offence has been committed and that the elements are made out. So for drug drive, drink drive, even a case where somebody is seriously injured or unfortunately killed as a result of a traffic offence, those won't be classed as offensive
So
moral turpitude.
it depends when someone is, so when someone is killed, it depends if that's vehicular manslaughter, involuntary manslaughter, those can involve moral turpitude. But strictly, a strict driving under the influence of alcohol is not moral turpitude, because I don't want to say it doesn't cause any harm because it certainly has the potential to, but it's not an evil offense. It doesn't create a serious amount of harm in itself just by operating a vehicle under the influence of alcohol. But one thing that you mentioned is drug driving. And while drug driving is not moral turpitude, it's a drugs offense. And outside of the realm of moral turpitude, drugs offenses come with their own potential to bar someone from traveling to the US. So when we look at offenses under the US immigration lens, we look not only at moral turpitude offenses, whether the crime involves moral turpitude or doesn't, but we look at whether the crime involved any controlled substance. And if it could involve a controlled substance, it is an offense that will stop you from using ESTA and stop you from getting a visa without any evil intent or harm to anyone else. Moral turpitude is treated a bit separately. We look at those offenses that are not drug related to whether or not there's intent, there's serious harm committed, and decide whether or not the underlying offense involves moral turpitude.
So I'm not sure whether this requires further explanation, but I was going to ask you when and why are this definition of offences of moral turpitude, when are they relevant for US travel?
So they're always relevant. And the reason they're always relevant is on the ESTA application, which is for the people, 99% of Brits going to the US on holiday, you'll go on ESTA. The question on the ESTA application is whether or not you've ever committed an offense involving serious harm to another or to a government authority. And the definition of serious harm is moral turpitude. So most people, including a lot of lawyers, don't know how to define moral turpitude. And as I said, it's kind of an amorphous concept.
Mm-hmm.
Asking a person who's not a lawyer to fill in a form that says, have you ever committed an offense involving moral turpitude, is ridiculous. And the Customs and Border Protection finally realized that they used to ask that question on the visa waiver on the old green form, and everybody ticked no because nobody knew what moral turpitude was. Mm-hmm. So they now ask you if you've ever committed an offense involving serious harm. The way they define whether the offense involves serious harm or not is whether the offense involves moral turpitude. So I get the question all the time asking, well, how do I know if I committed an offense involving serious harm? And the definition of serious harm is moral turpitude. How do I know if it's moral turpitude? So while they've changed the language, they haven't really changed what they're asking. And it is always better to, before you make the ESTA application, if you've ever been arrested for any reason, to consult with an immigration lawyer. And the reason I say that is for purposes of ESTA, an arrest is enough. You don't have to be cautioned or convicted. You don't even have to admit to the offense. As long as you've been arrested, it clearly asks on the ESTA application, have you ever been arrested or convicted? So because the arrest is enough, if you disclose an arrest on ESTA, you will need to apply for a visa. You won't be allowed to travel without a visa.
So possibly a controversial question. What if you tick the wrong box, whether intentionally or unintentionally? How are the US Immigration Authority going to know whether you've been arrested if you say you haven't been? What are the consequences if it is discovered that you've incorrectly filled in an ESTA application?
So one of the reasons that they stopped using that green form on the plane was because if you made a mistake on that form, or you realized at 35,000 feet halfway across the Atlantic, I should have ticked yes, the remedy was present yourself to the nearest US embassy, which is impossible to do when you are en route to New York.
Yeah.
So they've moved everything out of the US and said you must apply for ESTA first before we'll even let you board the plane. Mm-hmm. The reason they did that is because they can then do a background check on you. So most people are cleared for ESTA within 15 minutes or so. It can take up to 72 hours. So if there is anything in your history, you might not be cleared immediately. It will go for manual review. Someone will look at your history and decide whether or not you're eligible for ESTA. If you make an honest mistake and you tick the box that says no, and you didn't realize that you had been arrested for an offense involving moral turpitude or one of these serious harm offenses. So let's say you stole something while you were at university, for £5, you were cautioned and you think this was nothing and it's been stepped down in the UK under the Rehabilitation of Offenders Act. I don't have to tell anybody. I'm just going to say no. If you do that, you still may not be able to enter the US because we share fingerprint records between the US and the UK, and every visitor to the US is fingerprinted at the border. So the fingerprint records can flag up at the border, and Customs and Border Protection can see that there's an arrest in your history. They may not necessarily know what the arrest is for. They can just see that there's what we call a hit. And if that's the case, then they'll question you and determine whether or not they can admit you to the US. So if you said to them, for instance, the hit is for drink driving, which is not moral turpitude, it shouldn't preclude you. One standard drink driving offense shouldn't preclude entry on ESTA. Your fingerprint records may flag up, but you may not be ineligible to enter the US. If it's something like a theft offense, even shoplifting, that is moral turpitude. They're not going to allow you to enter the US. They're going to tell you, based on this offense, you can't come in. You need to apply for a visa. But what they're not going to do necessarily is if you can say to them, look, I had no idea that this old offense for £5 was serious harm. I honestly thought I could say no. They're not going to bar you for life for misrepresentation. Right. If they have any reason to believe that you knew you should have answered the question yes, and you hid it from them, and I see this all the time in the turnaround reports that I review from Customs and Border Protection, they ask, why didn't you say anything? And people will actually say, well, I knew if I said something, I wasn't going to get into the US. That's pretty clear evidence that you intended to hide something from the US government. If you are that brazen and you say it to them, or if they have reason to believe that you should have known, that you should have ticked the box yes, and you willfully tick the box no, they can bar you for life for misrepresentation. And then you need to go to the embassy, apply for a US visa, and apply for a second step called a waiver of inadmissibility to ask them to overlook the fact that you committed fraud on the US government. However minor that fraud may be, we still treat it as fraud, and it can be very difficult, if not impossible, to overcome.
Right, goodness me. I'm just thinking as you're giving the example of a very minor shoplifting offence. Something I think people don't realise here is if you don't buy a ticket to go on the tube, or if you try to evade the train fare, that is classed as an offence of dishonesty. I'm assuming that would also,
theft of services is certainly a crime involving moral turpitude.
Yeah, goodness.
And the British Transport Police have they are the police. They can give you a caution. They can send you to the magistrate's court. They have policing powers. So if you're convicted by the British Transport Police for theft of service or fare evasion, that's a conviction for moral turpitude. And the other thing that I wanted to mention, which is unique to the UK, is the idea of a caution. It's something like 200,000 are given a year. And they catch you with a small amount of marijuana at a festival and they say, give me that and sign this caution. Or you're in a fight at a pub and you're charged with assault and they say, sign this and it'll go away. By signing that caution form, if you read the caution form, it actually says, by signing this, I admit to have committed the offense and to all of the elements of the offense. And I further understand that by signing this, I may be prevented from traveling to certain countries in the future. So even taking a police caution is, even though it's not necessarily an arrest under UK law, it's an admission for US purposes, which under immigration law is tantamount to a conviction.
So let's say we're going back to the poor soul who has mistakenly completed the ESTA saying that there isn't anything that they need to declare. They get to customs in America and it gets flagged up, at that point, would they be arrested or would they just be?
They can't be arrested. So there are also two different ways of entering the US. So if you use ESTA and you present yourself at the port of entry, Customs and Border Protection to inspect you, you have no rights, none. When we talk about visa waiver, we waive all of our rights using visa waivers. So yes, we waive the responsibility of having a visa, but we also waive any right to counsel, any right to a phone call. So you are just at the mercy of Customs and Border Protection. They can't arrest you. The worst they can do is refuse your admission. And depending on how they do that, there are certain consequences. If they believe that you intended to commit misrepresentation, and had you disclosed that offense, you wouldn't have been able to come into the US, and you knew about that, or you should have known about it, they can bar you for life for misrepresentation at the border. And all they have to do is get a senior officer to sign off on that, and they return you to your home country. You have no right to appeal that, and you have to apply for a visa and a waiver of that inadmissibility to Customs and Border Protection as part of the visa application.
Okay.
The other thing that they can do is, if they think you violated immigration law, or you're not a bona fide visitor, or something in your declaration to the border, at the border is not genuine, they have a power called expedited removal, which means we're not going to put you in front of a judge. We're just going to say, sign this, we'll remove you from the US, and now you're barred for 5 years. After 5 years, you don't have to apply for a waiver any longer, but you have to be out of the US for 5 years.
Right.
So they have a lot of power at the border, and you have very, very few rights. If you're traveling on a visa, you have more rights. You have at least the right to ask to be put in front of a judge, but most of the time people don't ask that. They've been traveling for 10 hours and they're just told you can't come in, and they turn around and go home. But I recently taught an immigration law class, and it was taught to a class of American law students. And I asked them, prove you're American. You at the border, prove you're American. You board the flight in London, you drop your passport on the jetway, you're at JFK, prove you're American. And they said, well, I get a copy of my birth certificate. Okay, where will you get that? I'll call my mom. You don't have the right to a phone call. Well, I'll call a lawyer. You don't have the right to a phone call. You don't have the right to a lawyer. Well, of course I do. I'm American. Not until you've proven it. Until you've proven it, you are treated like any other arriving alien, and you have zero rights at the border.
And will they prevent you from making a phone call to be able to resolve it?
If the officer has reason to believe that you just dropped your passport and that you might be an American, they can allow it, but you don't have the right. It is completely discretionary at the border. You can ask, and if they're nice to you, maybe, but you don't have the right. And there was actually a case that I taught about a woman who was American, presented herself without her American passport. It had been lost, and she claimed to be American, and they didn't believe her. They didn't allow her to make any phone calls. She was born abroad, but was born to American parents, so she had a passport, and was removed to Mexico and spent 40 days in Mexico until she could prove that she was American, and she got her new passport. When she went back to the States, she sued the US government and lost, because they said, we treated you like we treat anyone else arriving at our borders. Until we know you're American, you don't have rights.
Wow. Oh, that's a bit of an eye-opener, to say the least. Okay, so I don't know whether we've covered this. I was going to ask you, is an arrest disclosable even if not convicted? I think you have covered that. An arrest,
on ESTA,
caution.
it certainly is. An arrest, a caution, a warning, a conviction, they are all disclosable on ESTA. The big difference is that an arrest is enough to prevent travel on ESTA. It's not necessarily enough to prevent getting a visa. So it may mean that if you have to disclose your shoplifting offense on ESTA, you're not going to be able to travel without a visa. But if you go to the embassy and say, look, I'm 46 now, when I was 22, the rugby club made me steal something worth £5 to initiate me, There are waivers available for past offenses. There are certain exceptions to inadmissibility based on the seriousness and the recency of the offense, the amount of time, if you served any prison time, the sentencing powers of the court that sentenced you. So the embassy can take all of those into consideration. You should get an immigration lawyer to present your case and why you fall into those exceptions to the embassy. But they can consider all of those, and they don't necessarily have to refuse you a visa just because you were arrested, even if you were convicted. But an arrest on its own is enough to stop you from traveling on ESTA.
Okay. So the next thing, I think you used the terminology standard drink driving before as well. I'm not sure whether how that is sort of classified, but
So for US purposes, one drink driving offense, no drugs involved, you were driving erratically, or you pulled over at a traffic stop, your blood alcohol level was over the legal limit, and you were convicted of drink driving. No harm to anyone else. No drug, as I said, no drugs involved, and it's your first and only drink driving offense. That is not necessarily going to stop you from getting into the US using ESTA. Any other aggravating factors certainly may, and a second or subsequent drink driving offenses also may. So what we normally recommend is if you have, and your fingerprint records can also flag up at the border, even if it's just one drink driving offense. So what we normally recommend is before you travel to the US, you get a copy of your police certificate, the ACRO police certificate that has your offenses on it. If they're within the past 10 years, they're usually on the certificate itself. If not, we recommend that people apply for a subject access statement from the ACRO that has everything on the police national computer about you on it. Those take about 30 days to get and can be expedited. The standard police certificate takes between 3 and 10 days, depending on how much you're willing to pay. But we suggest that you look at your police certificate before you travel to the US. If the only thing that's on there is a single offense of drink driving, even if it comes with disqualification, comes with a fine, that's not going to be enough to stop you from using ESTA. But we always advise that you should present that certificate along with a letter from a lawyer. In case your fingerprints do flag up, they're going to see that there's a hit, but they're not going to see what it's for. So if you present the police certificate saying, look, this is my only offense, and I have a letter from a lawyer explaining why I should be allowed into the US despite the fact that I have this offense, that's usually enough for Customs and Border Protection to admit you.
Okay, and then just moving on from that, what if it's a drink drive offence? There is no harm to anybody else, but because it's a very high reading, you are sent to prison. Does the sentence have an impact on whether it's going to have any problems for you when you're trying to get to America?
Not necessarily, not on ESTA. The difference between ESTA and I know that this doesn't make a lot of sense, but this is the way it works. If you have a drink driving offense, even one that has resulted in some prison time, that is not necessarily going to stop you from going to the US on ESTA. When you apply for a visa, so a visitor visa, a work visa, what we normally see is people have a drink driving offense, they go for business meetings. On ESTA, totally fine. Then their US counterparts decide they want to hire them and they sponsor them for a work visa. They go to the embassy to apply for the work visa. And at that time, the embassy says, oh, you've got a drink driving offense. You need to go to the embassy's doctor. You need to have, so any drink driving offense within 5 years or 2 within your lifetime requires that you go to the embassy's doctor, that you have a drug and alcohol screening. The alcohol screening is they test liver enzymes, they talk to you about your lifestyle, how much you drink. The drug test is blood and urine. And they have to do that as a matter of course for anyone who's been arrested for drink driving within 5 years, or again, 2 in their lifetime. And the doctor gets to make a determination whether or not they think you pose a risk to yourself or others because of your drinking or drug use. If they do, they have the power to tell the embassy not to issue the visa. So it may not preclude ESTA, but when you apply for a visa, it may actually be a factor that the embassy considers in whether or not they can issue you the visa.
Wow. Okay. I think, yeah, so the ESTA would be what you use for the holiday, just to go on holiday.
A holiday, a business meeting, that kind of thing.
So one drink drive conviction would not prevent you from using the ESTA.
Yeah, so the Customs and Border Protection just put out a cable on the 10th of March of 2022 called Entering Canada and the US with a DUI.
Okay.
And in that cable, they've said a single DUI is not going to prevent you from traveling on ESTA. Anything aggravating or a second DUI offense can, but their position is clear that a single DUI will not. But again, they can't see the offense at the border, so it's a good idea to have your police certificate and/or a letter explaining what the nature of the offense is and why it falls under that exception.
Okay, and the aggravating features, is there a list of what is classed as aggravating, or is
No,
it
it's really
open to
anything
interpretation?
other than just being over the limit, driving erratically, being over the limit, a normal sort of traffic stop, DUI, any harm to anyone else, a second, certainly a second offense. Those will all be aggravating features.
Okay. We've talked about people that they manage to basically, well, they purposefully give incorrect information and hope that they don't get discovered. So we know that that is not a good idea. That could mean forever you cannot enter.
No, and people do get caught out because the system wasn't so sophisticated. And people will travel for years. Some of our clients tell us, but I can't understand why I got caught. I've been traveling for 15 years and no one ever said anything. Legacy fingerprint records get uploaded on a regular basis. And so you never know when you're going to be the one whose fingerprint records are now in the system. Maybe they weren't there the last 10 times you traveled to the US, but if they are there and they flag up, what you can't say to Customs and Border Protection is, well, I've gotten away with it for 15 years, so I figured I would just keep doing it. So it's a good idea to take advice before you make your first admission to the US, before when you are applying for ESTA, and before you get on the plane.
And probably the least of the person's concerns, but just to satisfy my curiosity, if you are discovered having given that incorrect information and you're denied entry, who has to pay for the plane home?
You do.
Really? Right. Okay. And it's immediate. There's no
you hope
the
it's
cheapest
immediate.
flight.
The best thing that it can be is immediate, because if it's not, you have to stay in an immigration detention center until they have a flight for you.
Oh dear.
So the best that you can hope for is you arrived on the 5 o'clock flight and the 7 o'clock flight is still going and you can get on that. Because if that's the last flight of the night, you're overnight at an immigration detention center until you can get the next flight in the morning.
And I'm assuming they're not particularly pleasant to stay in.
It's not a Hilton. It's some airports do have detention centers or holding centers built into the airport. For those that don't, you're actually taken to an immigration detention center off-site as anyone else who's in immigration detention would be.
Right. Okay, I think before we even entered this conversation, it was very clear, don't give incorrect information on an ESTA. It's just not worth it. Okay. And at what point would you say to seek your advice? I know that we have been recommending you to our clients for a number of years. I think sometimes it's been invaluable. Sometimes it might be a little bit premature and unnecessary. When would you say it really is important to try to get that advice from you?
It's never premature, because anyone who thinks that they might want to travel to the US in future should really think about the potential immigration consequences of any foreign arrest. We work with a lot of criminal lawyers and people who have criminal issues around the world. And sometimes we'll get involved just when they're arrested, because if an immigration lawyer can talk to the solicitor that is handling your criminal case, and we can say, if they admit to this, it's not moral turpitude. But if they admit to that, it is. And then the criminal solicitor can work with the prosecution service and say, my client will admit to this, even if the fine is higher. Can we admit to a lower offense? Can we be convicted of a lesser offense? It may mean that there are either lesser or no immigration consequences. So certainly for people who make regular trips to the US or who have business interests in the US, getting an immigration lawyer involved as soon as you're arrested can make a huge difference. For those who don't necessarily, it's not at the forefront of your mind to think, I'm being arrested, what if I want to go to the US someday? It's better to talk to an immigration lawyer before you make any plans to travel. What you don't want to do is buy the ticket and think, well, I'll just try on ESTA and then have second thoughts, contact a lawyer to say, you can't take this trip, you have to go to an embassy, and it's now going to take you 6 months to be able to get a waiver of this criminal issue. You won't be able to take the trip you paid for. So as soon as you can talk to a lawyer, it really is beneficial.
Okay, that's great. Now, I think we were making quite a few distinctions between drink driving and drug driving, and there's a big difference from the US immigration perspective, isn't there? Do you want to explain a little bit more about that?
Yeah, so we have our schedule of controlled substances, and any offense that involves anything on that schedule of controlled substances is going to be a ground of automatic inadmissibility to the US. So that means drug driving. That means I got cautioned for a little bit of marijuana at a party. That is an automatic bar to the US. That means no ESTA, and it means no visa. So in the case of moral turpitude, where I said depending on the length of sentencing, depending on a number of factors, you may not need a waiver, or you may need a waiver. For every drug offense, even a caution. So again, the arrest is going to be enough for no ESTA. But even a caution is going to be an admission of guilt for a visa. And the big difference between moral turpitude and controlled substance offenses are, for moral turpitude, you have to admit to the essential elements of the offense. There are no essential elements for controlled substance offenses. It is a controlled substance and I possessed it. So that's all that they have to prove. And if you have a caution, that is an admission that you possessed a controlled substance. Whether there was ever a field test done to prove that it was a controlled substance, you've admitted to it. So a caution or a conviction is going to be an automatic ban on ESTA and for getting a visa. And the only way to overcome that is to apply for the visa, usually go see the embassy's doctor, do a drug and alcohol lifestyle analysis. If it's within a year of having been arrested, it's very unlikely that you'll get a recommendation from the doctor to be able to issue the visa. That goes for drink driving as well. So even if you've been able to travel on ESTA with your drink driving offense, and you apply for a visa and are sent to the doctor, if the drink driving offense was in a year, they're generally not going to recommend the visa. But certainly for drugs, they're not going to recommend the visa if it's within a year. If it's outside of a year, you have to show the doctor that you are not a drug user, that your lifestyle doesn't present any harm to yourself or others, and you have to apply for what we call a waiver of inadmissibility, which means I am ineligible to receive a visa. The embassy would like to give me this visa, so they will recommend a waiver to Homeland Security, send my case to Homeland Security with their recommendation, and ask Homeland Security to overcome the ground of inadmissibility. And when they've done it, then the embassy can issue the visa. That takes between 4 and 6 months after the visa interview. So if it takes 2 months to get seen by the embassy, another month to go to the doctor and get the results sent to the embassy, and then go through the waiver process, you're looking at 8 months or so before a visa can be issued. So you're going to want to prepare for that. Again, you're not going to want to buy tickets to the US before you know what the outcome of your application is going to be. The good news is, if they recommend a waiver at the embassy, whether it's for drugs or for moral turpitude, with 99% of the cases, they are approved by Homeland Security with the embassy's recommendation, unless Homeland Security finds something in their records about you that the embassy didn't know about. But it's usually an approval, and then the embassy can issue the visa. The big things to note for British travelers is that most times you apply for a B visa, which is our visitor visa. Brits are given 10 years. So it means you get a 10-year multiple entry visa. If you need a waiver, the maximum you can get is 5 years on the visa, because waivers can't be extended for more than 5 years. And every time you need to apply for a new visa, so you have your visitor visa with its 5-year waiver, now you get a job offer and you need to apply for a working visa. Every time you apply for another visa, you have to go through that waiver program again, even if you've already been granted one.
For life, you have to do that.
Yeah.
Gosh, okay. Is there any difference in the situation for a drug offense if it's legal marijuana use? So it's basically prescribed for medicinal purposes.
No, we don't have legal marijuana in the US, despite the fact that we do have legal marijuana in the US. So I'm sure you've heard the news reports, certainly for years now, it's been Colorado, California have legal marijuana, even recreationally legal. There are some states where it's medically prescribed, other states like New Jersey, where until last year it was medically prescribed and now it's recreational. People have a false sense, and it's not their fault. The government does a terrible job at publicizing this, but there is a false sense that marijuana is legal in the US. If I'm going to the US, they don't care that I have a drug offense. Or if I get to the US, I can buy marijuana legally. I'm going to vacation in California. I'm going skiing in Colorado. I can go to a dispensary. Unfortunately, because we have a federal and state system in the US, states can give more rights to the federal government. So the federal government has not made marijuana legal. Immigration is federal law. So unless you are a US citizen, you are covered by federal law, by federal immigration law. Marijuana is not legal for you to possess, even if it's legal in the state where you are. And we see so many people, usually students, get caught out. They go to university, they study abroad in California for a year, and they think, all my friends are going to the dispensary, I'll go with them. They use their passport as their only form of ID. They give their passport at the dispensary. Because of the US money laundering rules, they have to give all of their client records to the Department of Treasury. Treasury sees, oh, I've got a foreign national on this list. They've used their British passport. I have to refer that to the Department of State. The Department of State can revoke your visa because you bought marijuana legally in the United States.
And does that happen?
All the time.
Oh, gosh.
And it happens a lot to students. It happens to a lot of people in the artist and entertainment space. The other thing that we see is a conviction for a small amount of marijuana, a caution in the UK. Because it is illegal under federal law and it is still on the federal controlled substances list, anything that contains, I think it's 0.03% THC is on the controlled substances list. You are ineligible for a visa. It's a controlled substance in the US. And that even comes to admitting an offense. So if you're in Amsterdam, where everyone believes that it's legal, I'll leave the legalities of Dutch drug law aside, but you can go to a coffee shop and buy some marijuana. If they ask you at the border, have you ever tried drugs? And you say, well, yeah, I smoked weed in Amsterdam because it's legal. It's not legal in the US. You've now admitted to possessing what we classify as a controlled substance. You're inadmissible to the US.
So basically, in conclusion, doesn't matter what the laws of the country you live in are, you visited are, it's American law, and it doesn't matter what circumstances your possession or use of the drug came about, it would be classed as a bar to entry, basically.
And we've seen recently CBD oil, which people are using for all sorts of over-the-counter treatments. You have a sore back and you buy cream with CBD oil in it. I had a client who bought some CBD oil. He's an athlete. He bought the oil at Holland & Barrett in the UK, brought it with him to the US. The sniffer dogs at the border sniffed, they found it, and they said, what is this? And he said, it's CBD oil. I got it at a chemist over the counter at a vitamin shop. And they said, okay, but you can't bring it into the US. It has a trace of THC in it. We don't have a field test at the border to tell us how much THC. So we have to assume that it's over the legal limit and you can't bring it in, and you are now permanently inadmissible for trafficking a controlled substance. And I had another client who bought it in the US where it was legal to buy over the counter at our Holland and Barrett. And he left and went back into Florida, same thing, drug dog. And he said, but I bought it here. That's fine. You can buy it here. When you take it out of the country and bring it back, you're importing a controlled substance, lifetime ban. We got both of those overturned, but it took us 8 months.
Right. And I'm sure a fair bit of money in legal fees and anxiety and yeah.
And every time those athletes want to go back to the US, we have to do that process over again.
It's crazy.
Yeah. And another thing I wanted to mention about drink driving, we have something called a Prudential revocation in the US. The general rule says that if you're in America on a visa and we believe as a government that you are physically in the United States, we can't revoke your visa unless we have some intelligence that says you're a threat to the US government, and then we can revoke your visa while you're in the US. The only exception to that is drink driving. If you are arrested for drink driving in the US without even being convicted, your visa is automatically revoked within about 24 hours. The State Department gets the list of people who have been arrested for drink driving. They communicate that to the consular posts around the world that issued those visas, and within 12 to 24 hours, your visa is canceled. What that means is you have the right to stay in the United States because you've been admitted, but if you leave, that visa is no longer valid for you to travel back to the US. You have to go to the embassy, apply for a new visa, go see the embassy's doctor, go through the drug and alcohol testing, and maybe not get another visa if that arrest was in the past year. And the reason they can do that based on arrest and not on conviction is because we don't make it a criminal ground of inadmissibility to the US, we make it a health ground. So we say you engaged in a behavior that puts yourself and others at risk. That's a health ground of inadmissibility. Just on arrest, just as soon as you blow over the limit, your visa is canceled.
Okay, this is a bit of a curveball here. I'm sure you'll be able to handle it. What if you've got no criminal record, but you are a recovering addict and you attend NA, AA? Would that have any impact on your ability to? Oh, really? Go on.
Yeah. So yes and no. If you've got no criminal history, but you're going to, you don't have to disclose to the government authorities that you're in AA. If it's Narcotics Anonymous, there is a question on the visa application that asks if you've ever violated the law pertaining to a controlled substance. If you are 100% honest, yes, you have. You possessed a controlled substance. So you, under the strict reading of the law, you're supposed to disclose that to the US government. If you do, the likelihood is if you've been clean for 5 years and you say, yes, I did possess, I used to be a cocaine addict. Now I'm not. Here's my 5-year chip. It's usually not going to have any effect. They may send you to the doctor. If it was 5 years ago, they probably wouldn't. There's no criminal history. It's probably not going to have a huge impact. And as a matter of fact, I've done visas for people to go to the US so that they could go to rehab in the States.
Okay.
And as long as you can show that you are not an active drug user or that you've never been arrested or convicted, because that's an automatic ban. But without any criminal history, if you can show that you are not, you don't pose a threat to yourself or others based on drugs or alcohol, there's no automatic reason for them to prevent you from going to the US. It's discretionary. And what we do then as lawyers is present the case to the embassy in a way that we hope makes them exercise their discretion in favor of the applicant.
Sure. I think we've talked about this before, but for the purpose of people watching this interview, I've noticed some time ago, just from visits I've made to the States, the social media disclosure on the ESTA. And I think previously, well, it's still voluntary, it's optional, isn't it? But tell us what your recommendation is to people when they are completing the ESTA, when it asks for that optional social media handles question.
I think it's so funny that they've made it optional. It is optional. My recommendation is don't put it down if you don't want to put it down. And that the reason my recommendation is that it's optional and you do what you like is if they want to access your social media, they can compel you to log into your social media accounts at the border. So just because you haven't put it on the form doesn't mean they can't compel you to log in and show them. Uh, it is almost laughable that they say it's optional. If they want you to put that information down, then they should ask you to put that information on the form. I have clients all the time who come to me after they've been refused admission because of something found on their social media. It's usually on their LinkedIn where they say, I'm working in California and they don't have a work visa. Or it's or even they're out of office that says, I'm working from our New York office for the next 3 weeks. And they say, oh, do you have a visa to work in your New York office? No. Well, that's working without authorization. So they will look at your phone, whether you put your social media addresses or handles down on your ESTA application or not. If they have a reason to ask you follow-up questions and they believe that you are working without authorization, that you're engaged in some sort of drug use, that you're doing something that is not, that doesn't put you into the class of bona fide visitors with a clean history, they can compel you. Again, at the border, you have no rights. So you have to they will put you in detention until you unlock your phone for them. And I've had clients come to me and say they read my WhatsApp messages. And in my WhatsApp messages, I said, how much did I drink last night? And my friend replied, oh, don't worry about the drinking. It was the few lines of cocaine that we did that sent me over the edge. And that's enough. It's in your WhatsApp.
Wow. I'm gobsmacked. Sorry, I didn't realize that your rights are completely non-existent in that
Yeah,
way, and that could be.
I had a client who was a very, very senior corporate officer. He had been working in a multi-million-dollar job, decided that he didn't want that job anymore, and he was on a visa.
Mm-hmm.
His severance package in the US was contingent on the fact that he leave the US and not work for anyone else. So he left and went back to his home country. His young son was desperate to go back to the US to be with to finish high school there, to be with his friends and to finish. He had, I think, 1.5 years left. The time difference, he was trying to do it online, but the time difference was killing him. So they went to the embassy. The son applied for a student visa. The parents said, we don't have to work. We don't intend to work. And we just have visitor visas so that we can go and accompany our son while he finishes high school. The embassy gave them visas. They flew into the US. They explained what they were doing. They looked at all of their phones because they said, well, this doesn't sound right. How could you possibly support yourself for a year in the US without working at all? And they said, here are our tax documents. Here's everything we can prove to you, like we proved to the embassy, that we just want our son to go to school. They looked at their phones. The mother of the family had sent a message to her family saying, they're just about to close the door on the plane. I'll text you when we get home. They owned a house in the US because they had been there for so many years living and working. She used home colloquially as we would. I'm going home. The the Customs and Border Protection officer said, you said home. You intend to live here. You're just a visitor. You don't have the right to live here. They removed them from the US with a 5-year ban. We got it overturned and the visas were reinstated and they're in the US. The son is at school now, but he missed another 4 months of school because a border officer didn't like what somebody said in their WhatsApp. So go ahead and put your LinkedIn and your Facebook profile in, or don't. They're going to either
if they want to, they can get it,
or they're going to compel you to show it to them.
I'm just amazed. I mean, I've had some experiences of going through customs and you do wonder why are they so frosty? Why are they so sort of.
So there's a big difference between Customs and Border Protection and the embassies. The embassy officers, the ones who adjudicate visa applications, they're trained in immigration. They go to the Foreign Service Institute. They're given language training and cultural training. So they have more time to spend with someone and understand what you're going to be doing in the US and whether or not what you're going to be doing in your history is in line with you being able to have a visa. Customs and Border Protection are law enforcement. They have 30 seconds to clear you. they have 300 people per flight, and if they tie up the airports and they're not getting people through, and people complain about wait times, they get reprimanded. They don't get any brownie points for admitting people. So if they think there's a reason not to admit you, it's just easy for them to say, I don't have more than 30 seconds for you. Go home and apply for a visa. So it's a very different experience than going to the embassy, where you can spend, it's not a long time, it's maybe 5 minutes, but compared to 30 seconds with a law enforcement lens, 5 minutes with a diplomacy and can we facilitate travel to the US lens is a very different experience.
Well, Daniel, I have to say, I have spoken to you many times before, but this one's been a real eye-opener for me, and hopefully it's been really helpful for people watching this. I know that you have been able to help many of our clients, and obviously if people do want to seek your advice, obviously we've provided your firm name and details of how to get in touch. Before we finish off, is there anything else that you'd like to cover today?
No, I think that's probably scared everyone enough. The vast majority of people traveling to the US don't have these issues.
Yeah.
There is still a huge number of people who visit the US every year, and I wouldn't worry, but the things to take note of are, is there something in my history that may flag something up at the border that may cause the Customs and Border Protection officer, in the 30 seconds that they have to deal with me, to think I may not be able to enter the US. If there is, it's not a bad idea to talk to a lawyer. Usually we can give the advice that I give most often to your clients who contact me is the advice saying, yes, with one DUI, you can travel to the US. I can provide you with a letter if you want the comfort of doing that, get a police certificate, you're fine. Yeah. And in a lot of cases, that's going to be the advice. And I don't even charge for that. But if you're afraid to talk to a lawyer because you're afraid to know the outcome, or you think, I don't know if I should or want to pay a consultation fee for this advice, if you think about you not knowing the outcome until you get to the border is far worse than having a lawyer tell you, at this point, I don't think you should travel to the US, but we can do X, Y, and Z to facilitate your travel. And the amount you're going to pay for a consultation or even a visa application is maybe going to make the difference between spending £10,000 on a family holiday to Disney or booking those tickets and not being able to take the trip.
Yeah, absolutely. And I think possibly many people will be guilty of assuming there's an element of sort of reasonableness. As Brits are all for politeness and being reasonable. Doesn't seem to be something that's applicable.
I'll just tell Customs and Border Protection that everything's fine. It's not the best tack to take.
Well, thank you so much for taking the time out to explain all of this to us today. Really appreciate it. And as I say, we will continue to get clients to reach out to you if there's a relevant issue they need help with.
So I really appreciate it. Thank you so much for having me.
It's a pleasure.